Thanks for being here. Over the next hour, we're going to talk about something that's quietly become one of the riskiest parts of running a rental: how you screen applicants, and what happens when a piece of software is doing part of that screening for you. The title is the whole argument in 5 words. You can't outsource the denial. When a screening tool scores an applicant and you act on that score, the decision is yours, not the vendor's. Yours. And in the last 2 years, the rules around that decision have shifted in a way most operators haven't caught up to. Let me show you the case that made this real. This is Lewis versus SafeRent Solutions out of the federal court in Massachusetts. A tenant screening company built an algorithm that produced a score, the SafeRent score, and landlords used that score to decide who got an apartment. A group of applicants, many of them Black and Hispanic voucher holders, said the algorithm scored them unfairly. The case settled in late 2024 for about $2.3 million. But the dollar figure isn't the part to remember. 3 things are. First, the court refused to let the vendor off the hook. SafeRent argued, "We don't make the final call, the landlord does, so don't blame us." The judge said no and denied the motion to dismiss. A screening company can be on the hook even when it's the landlord who clicks approve or deny. Second, and this is the part for this room, the landlord's denials were the scrutiny. Owners who relied on that score were squarely in the frame, not just the software company, the people who acted on the score. And third, the product itself got rolled back. As part of the settlement, SafeRent can't show its score for voucher applicants anymore, and any future score has to be independently validated. A lawsuit changed a national product, so that's the ground we're standing on. Keep this case in the back of your mind for the whole hour, because everything else connects to it. Here's what a lot of people got backwards over the last 2 years. Through 2025 and into 2026, the federal government stepped back from this area, pulled guidance, proposed rolling back rules. And the natural reaction is, great, less regulation, less risk. That's the trap. The rulebook didn't get simpler. The liability didn't disappear, it moved. It moved to 3 places. Private class actions, the SafeRent model, plaintiffs' firms litigating algorithmic screening directly, and they're good at it. Your state and your city, source of income bans, fee rules, fair chance ordinances. That's where your real compliance floor now sits. And the FCRA itself, the Fair Credit Reporting Act, a federal statute that never softened and is busier in court right now than it's ever been. So the exposure didn't shrink. It relocated to venues that are frankly less forgiving. And here's the uncomfortable part. Most of this trouble is unintentional. It doesn't start with a bad actor. It starts inside a normal screening process on a normal Tuesday with a well-meaning landlord. So here's what I want you to walk out of this hour able to do. 2 things. 1, defend the denial you make. Run a screen that holds up when a rejected applicant complains, even when a tool did the scoring for you. 2, see where the algorithm bites. Spot the specific ways a vendor's model can put you personally on the hook, not just the software company. We'll get there in 4 moves. First, the durable spine, the part of this that doesn't change no matter who's in the White House. Then the 4 landmines inside the screen itself. Then the current state of play, the recent shifts, which I'll flag as dated because they move fast. And finally, a workflow you can take back to the leasing desk. Let's start with the part that doesn't change with the politics. The 2 laws, consistency, documentation, and the 4 landmines. If you remember nothing else from today, remember this section, because it's true this year, it'll be true next year, and it'll be true under the next administration. 2 laws govern every screening decision you make. Think of them as 2 hats you're wearing at the same time. The first hat is the Fair Housing Act, 7 federal protected classes: race, color, religion, sex, disability, familial status, and national origin. Familial status just means having kids in the household. That's a big one people forget. And there are 2 ways you get caught under this law. The obvious one is different treatment, handling one applicant differently from another because of a protected trait. That can be blatant or it can be casual. A comment, a phrasing in an ad, a question you asked one person and not another. The second way is subtler, and it's where algorithms live. A neutral policy that lands harder on a protected group. A rule that looks perfectly even-handed on paper, applied to everyone the same way, but it disproportionately screens out people in a protected class. You didn't intend anything. The effect is what matters. Hold on to that idea, because it's the thread running through every landmine we'll cover. The second hat is the Fair Credit Reporting Act, the FCRA. And here's the trigger. The moment you pull a screening report on an applicant, you've taken on 4 duties, automatically. 1. Permissible purpose. You need a lawful reason to pull that report, and the applicant's authorization to do it. 2. Accuracy. The information has to be current, correct, and actually about this applicant, not someone with a similar name. 3. The adverse action notice. If that report drives the denial, or worse terms, you have to tell the applicant in a specific way we'll walk through later. And 4. Honor disputes. The applicant has the right to challenge what's in the report, and that challenge has to be investigated. The FTC enforces the FCRA, but here's the shift. Increasingly, it's private plaintiffs doing the enforcing, which means the risk isn't a regulator knocking, it's a lawsuit. How do these fit together with everything your state and city pile on? Picture a stack. At the bottom, the foundation is federal, the Fair Housing Act and the FCRA. That's your nationwide baseline. It applies everywhere, to everyone. On top of that sits your state, source of income laws, fee caps, fair chance rules, and on top of that, local, city and county ordinances, which are very often the strictest layer of all. The key thing, federal is the floor, not the ceiling. Complying with federal law is necessary, but it's nowhere near sufficient. And that leads to the single biggest mistake I see multi-property operators make, the portfolio trap. You build one clean, standardized screening process, and you run it everywhere. That feels responsible. It's actually the fastest route to a violation, because what's perfectly legal at your home property may be flatly unlawful 2 states over. The process has to bend to the jurisdiction. Here's why good, careful landlords still end up on the wrong side of this. It's not usually because they did something malicious. It's the structure of how enforcement works. Fair housing enforcement is complaint-driven and reactive. Nobody schedules an audit of your leasing office. Instead, it runs like this. An applicant gets denied, or just feels like they were treated differently. Then a complaint gets filed. And here's the catch, often weeks or months later. Then the agency comes to you and requests your records and a written explanation. And now you're reconstructing a decision you made half a year ago, frequently from memory. Look at the asymmetry there, because it's the whole risk. They have a written complaint, filed and dated. You have whatever you happen to write down at the time. If the answer is nothing, you're not defending a decision anymore. You're inventing a defense after the fact, and it shows. Which brings us to the 2 habits that protect you. The first habit, and if I could tattoo one sentence on every leasing office, it'd be this: consistency is the entire game. Inconsistency, not malice, is what generates most complaints. It's the well-meaning landlord who bends the criteria case by case. A little flexibility for the applicant they liked. A little more scrutiny for the one they didn't. Every one of those bends is a data point that you treated people differently. The fix is almost mechanical. Set your objective criteria before you advertise the unit, not while you're staring at applications. 4 of them typically. Your income ratio, say 2.5 to 3 times the rent, applied to everyone. Your credit threshold, a stated floor where local law allows one. Your rental history standard, defined and verifiable. and your allowable negatives spelled out in advance so you're not deciding in the moment what's disqualifying. Then apply the exact same numbers to every single applicant. No exceptions without a documented, non-discriminatory reason. Consistency isn't just fairness, it's your legal armor. There's a companion rule to consistency, and it's about sequence. Same steps, same order, every time. 2 steps. First, qualify. Check the applicant against your stated criteria: income, rental history, identity. Then, and only then, screen. Run the background and credit reports on the applicants who already qualified. Here's the part people get wrong, and it matters. Don't reverse the order. If you run the background check first, before you've qualified anyone on objective criteria, you've created the appearance that you're making decisions based on what's in that report, rather than on neutral standards. And a background report is full of exactly the kind of information that correlates with protected characteristics. Qualify first, screen second, every time. It's a small discipline that closes a big vulnerability. The second protective habit is documentation. And I'll put it as plainly as I can. In a complaint-driven system, the record is the case. 3 things you write down every time: the criteria you applied, the exact standards in writing, what you evaluated, income, history, the report results, and the outcome and why, the objective, non-discriminatory reason for the decision. That's it. It's not glamorous, and it takes an extra 90 seconds per applicant. But remember that asymmetry from a few minutes ago. When the complaint lands 6 months later, the person with contemporaneous notes wins, and the person reconstructing from memory loses. No notes equals reconstructing from memory equals losing. Write it down. All right, with those habits in place, let's go inside the screen itself, because there are 4 specific places where operators step on landmines: criminal history, credit, source of income and vouchers, and accuracy. We'll take them one at a time, and you'll notice the algorithm shows up in every single one. Landmine 1, criminal history. I want to start with the doctrine, because it changed recently in a way that's easy to misread. Here's the headline: the federal guidance changed in 2025, but the exposure did not. 3 points. First, blanket bans still bite. The policy of any record equals automatic no carries disparate impact exposure through the courts and increasingly through state and local fair chance ordinances. Remember that second way you get caught under fair housing? A blanket criminal ban is the classic example. It lands much harder on some protected groups than others. Second, HUD did step back. HUD withdrew its own criminal record screening guidance in 2025. But, and this is the trap, withdrawing guidance doesn't change the underlying Fair Housing Act. The statute is exactly as strong as it was. The roadmap went away, the liability stayed. And third, the fundamental rule: arrests are not convictions. An arrest with no conviction is not a lawful basis to deny someone in most jurisdictions. If your process or your vendor's algorithm treats an arrest like a conviction, that's a problem. So if the blanket ban is out, what do you do instead? You replace it with an individualized assessment. 4 factors: nature and severity. Weigh what the offense actually was, not just that some record exists. A decades-old misdemeanor and a recent serious offense are not the same input. Recency: how long ago it happened, and the pattern since. Time matters. Relevance to safety: does this actually bear on the safety of your residence or your property? That's the legitimate question. It makes me uncomfortable is not. And a chance to respond. Give the applicant the opportunity to provide context or mitigating evidence before you finalize the denial. Maybe there's an explanation. Maybe the record is wrong. Yes, this is more work than a checkbox, but it's the difference between a defensible decision and a discrimination claim you can't answer. Landmine 2, credit. And there's a trap built right into how we think about credit scores. Here's the trap, stated plainly. A credit score predicts credit repayment. It does not predict whether someone will pay their rent. Those are different things, and treating them as the same is the core critique consumer advocates make, and it's a live litigation theory right now. 3 consequences. Over-reliance is the risk. Leaning hard on a single score is exactly where automated screening quietly discriminates, because the score becomes a proxy for things it shouldn't. Vouchers distort it further. When most of the rent is paid by a subsidy, a credit score tells you even less about whether this person can cover their portion. And it travels with historic bias. Median credit score gaps that trace back to past inequities can import disparate impact straight into your decision, even though the number looks perfectly objective sitting there on the screen. So credit is useful information, but a credit score as a hard gate, especially an algorithmic one, is a landmine. And it's not just risky in the abstract. A growing number of jurisdictions now legally restrict how you can use credit history. Subsidy holders often get extra protection. Some states, California among them, specifically limit how much you can rely on credit history for applicants using housing assistance. The logic follows directly from the last slide. If the government's paying most of the rent, the applicant's credit score is largely beside the point. Blanket score minimums can be unlawful. That clean, nobody below 620 cutoff can violate local law, even though it feels like the most objective rule in the world. And the operating principle? Check the rule where the unit is. The limit is set by the property's jurisdiction, not by whatever you've always done at your home market. Same trap as before, different landmine. Landmine 3, and this is the one directly under the SafeRent case. Source of income and vouchers. Start with the number. More than 20 states ban source of income discrimination, plus a long list of cities and counties. Now, source of income is not one of the 7 federal protected classes, but it is a live, enforceable protection almost everywhere your properties are likely to be. So treating it as not a real rule because it's not federal is a serious miscalculation. And here's the fault line SafeRent ran straight into. The algorithm ignored the value of the housing voucher. It looked at a voucher holder and effectively asked, can this person pay the full rent out of their own income? When the whole point of a voucher is that they don't have to. The subsidy covers most of it. So the tool systematically penalized exactly the applicants the voucher program exists to help. And in every jurisdiction that bans source of income discrimination, doing that, whether it's you or your software, is unlawful. That's not a hypothetical. That's the case we opened with. Let me show you how that failure actually happens, step by step, because it's mechanical and it's invisible if you're not looking for it. Step 1. The model ignores the subsidy. It scores the applicant's income and credit as if they have to pay the full rent alone. Step 2. The voucher holder scores low. The tool flags a false affordability risk. False because the subsidy is covering most of the rent the model just pretended they had to pay. Step 3. The applicant gets denied. On a recommendation the landlord often can't fully see into. Step 4. You've now got a source of income violation, and it's automated, which means it's not a one-time mistake. It repeats on every voucher applicant, in every covered state and city, systematically. That's the danger with a bad model. It doesn't discriminate once. It discriminates at scale, quietly, on every application. If your tool scores voucher holders on a model that's blind to the subsidy, you may be automating a violation over and over. Landmine 4. Accuracy. The wrong person problem. Here's the duty that sits on you. The FCRA's maximum possible accuracy standard is yours to police. Not only the vendors, yours, because you're the one who acts on the report. 3 ways accuracy fails. Name-only matching. The report gets pulled on nothing more than a first and last name match and sweeps in some other person's records. There are a lot of John Smiths. Stale or sealed records, non-conviction dispositions, or records past their legal reporting window that should never have been in the report driving a denial. And mismatched files, data attributed to entirely the wrong applicant. In every one of those, the screening company may have made the error, but you're the one who denied someone based on it. The vendor's report said so is not a defense that's going to hold up. Which is why the next piece, the dispute process, matters so much. Accuracy isn't a one-and-done check at the moment you pull the report. It comes with an ongoing duty, and it has 3 parts. Applicants can dispute. They have the right to challenge the information in that report. That's baked into the FCRA. The generator must investigate. The screening company is obligated to actually look into the dispute within set timeframes. It's not optional, and it's not cosmetic. And the rule for you? Don't act on data you can't stand behind. If a record is unverified or it's being contested, denying someone on it is exactly how a single denial turns into a class action. When there's doubt, slow down before you deny. Now let's talk about the mechanic that, in my experience, gets flubbed more than any other. Adverse action. Here's when it fires. Anytime you use a screening report against an applicant, you trigger a formal notice duty. And against is broader than people think. It fires on a denial, obviously. You reject the application based on the report. But it also fires on a higher deposit. You require this applicant to put down more than others. And it fires on any worse terms, any less favorable condition driven by that report. This is the single most flubbed mechanic in the room, and it's also the easiest violation for someone to prove, because either the notice exists correctly or it doesn't. There's no gray area to argue. So let's make sure yours is right. Every adverse action notice has to give the applicant 4 things. Miss one, and the notice is defective. 1. The screening company's details, the name, address, and phone number of the firm that produced the report. Not you, the reporting company. 2. A statement that the company didn't make the decision. Clear language telling the applicant that the screening company did not make the rental decision. You did. This protects you, and it points the applicant to the right place to check the data. 3. The right to dispute. Explicit notice that they can challenge the accuracy of that report. And 4. The right to a free report. They can get a free copy from the screening company if they request it within 60 days. Those 4 every time on every adverse action. Build them into a template so it's not something anyone has to remember under pressure. And if a credit score was part of the decision, there's more, which is the next slide. When a credit score specifically drives the decision, you owe 4 additional disclosures on top of the 4 we just covered. The score itself, the actual number you used. Its range, the minimum and maximum for that particular scoring model, so the number has context. The key factors, the main reasons that drag the score down. And its source and date, who produced the score and when. Here's why this one stings. You can have a completely justified denial, a genuinely unqualified applicant, and still commit a violation because the notice was missing these disclosures. The denial was fine, the paperwork wasn't. Miss these, and the notice itself becomes the violation. So if you're using scores, your adverse action template needs these fields built in, not bolted on as an afterthought. One more thing on adverse action, and it's simple. Write it, keep it. Written beats oral every single time. 3 reasons. It's your proof of compliance. A written notice, dated and retained, is the thing you produce when a complaint lands. Try proving you gave an oral notice 6 months ago. It's the applicant's path to fix errors. Written detail lets them actually request the report and dispute what's wrong, which is their right. And it's the backbone of your paper trail. Combined with your criteria and your notes, that letter reconstructs the whole decision for you, cleanly. Oral notices might technically be allowed in some situations, but they help no one, least of all you. Put it in writing and keep a copy. So let's name the principle that ties this entire hour together. You cannot delegate compliance to an algorithm. SafeRent proved it in both directions at once. The vendor paid the settlement, so the software company was liable. And the landlords who relied on the score were the ones whose denials came under scrutiny, so they were exposed too. Both, at the same time. There's no version of this where you hand the decision to a tool and hand it the liability along with the decision. The tool is an input. You are the decision maker, and the law follows the decision maker. So the question becomes, how do you use these tools without inheriting their blind spots? Two answers. The first answer is to interrogate your vendor before you trust their score. Here are 6 questions. If your provider can't answer them, that tells you something. What data goes in? You should know what the model is actually looking at. How are the factors weighted? Which inputs move the score the most? Has it been validated, and by whom? Independent validation or just the vendor's word? Does it account for housing vouchers? After everything we just covered, this one is non-negotiable. Can it explain any single denial? Because you'll need to. Remember the adverse action notice. And who is liable when it's wrong? Get that answer in writing, in the contract. You'll notice a lot of vendors get uncomfortable around question 3 and question 6. That discomfort is information. A screening tool you can't see into is a screening tool you can't defend. The second answer, keep a human in the loop who can explain the no. 2 pieces, meaningful review and override. A person, not the software, owns the final decision, and that person has the authority to set the score aside when it's clearly wrong. If the override button doesn't really exist in practice, you don't have human review. You have a rubber stamp. And then the test I want you to actually use. Call it the plain English test. Before you send a denial, ask yourself, can I state the objective, non-discriminatory reason for this in one plain sentence? Income was below our stated 3 times rent standard. That's a sentence. The system flag them is not. If you can't finish that sentence cleanly, you are not ready to send the letter. Stop and go find the real reason. If there isn't one, you have your answer. That's the durable spine. And again, none of it moves with the political weather. Now we shift into the part that does move, the current state of play. I'm dating everything in this section because it's changing fast, and I'd rather you know exactly how fresh, or how stale, a given fact is. As of the middle of 2026, here's the federal picture, and it's a pullback on 3 fronts. 1. HUD withdrew a batch of fair housing guidance in September of 2025. That included guidance on criminal records and on digital advertising, among others, pulled from active use. 2. In January of 2026, HUD proposed repealing its disparate impact rule, the one at section 100.500. And I want to be precise here because it matters. That's a proposed repeal, not a final one. As things stand, the rule is still in effect until and unless it's finalized. Don't let anyone tell you disparate impact is dead. It isn't. 3. Back in May of 2025, the CFPB rescinded a set of its tenant screening interpretations, advisory opinions on background screening, on file disclosure, on accuracy. Now, if you're only half listening, all of that sounds like the pressure is coming off. The next slide is the most important one in this section, because it explains why the opposite is true. Here's the counterintuitive heart of it. Less guidance means more risk. Let me walk you through why. First, and this is the load-bearing point, disparate impact survives. The Supreme Court, in the Inclusive Communities decision back in 2015, built disparate impact liability into the Fair Housing Act itself. An agency changing its rule does not erase a Supreme Court interpretation of the statute. The theory is alive. Second, fewer safe harbors, same liability. The guidance HUD and the CFPB pulled was, in part, a roadmap. Do it this way and you're probably fine. That roadmap is gone. The liability it was helping you navigate is not. You're driving the same dangerous road with the map taken away. Third, the gap fills with private suits. Where federal agencies pull back, plaintiffs' firms and state actors move in. Nature abhors a vacuum, and so does litigation. And the proof it's already happening? FCRA lawsuits in federal court rose sharply in 2025 to what's projected to be an all-time high. The enforcement didn't stop, it changed hands. So if it's not primarily the federal agencies anymore, who is enforcing this? Three groups. Private class action firms, the SafeRent playbook. They litigate algorithmic screening directly, and they win real settlements. This is now a known, repeatable model, and the plaintiff's bar has the template. State attorneys general, actively working tenant screening practices, stepping directly into the space the federal government vacated. And state FCRA analogs. A lot of states have their own mini FCRA statutes and consumer protection laws, which give state regulators their own independent tools, regardless of what the federal CFPB is or isn't doing. The through line for this whole section, in one sentence: the venue changed, the exposure didn't. Don't mistake a quieter federal agency for a safer environment. Which is why your real compliance floor is now local. This is where the live, enforceable rules actually are in 2026. 4 categories to know. Source of income laws. More than 20 states, plus many cities and counties, protect voucher holders. This is the SafeRent territory, and it's widespread. Portable screening reports. States like Colorado, Washington, and Maryland now require you to accept a compliant screening report an applicant already paid for in defined circumstances, rather than making them pay again. Application fee limits. Some places cap what you can charge, like New York. A couple, like Massachusetts and Vermont, ban application fees outright. And fair chance ordinances. Local limits on how and when you can even consider criminal history. Here's the operating takeaway. You have to know these for each market you operate in, not the federal baseline, the local reality. That's your actual floor, and it's different from block to block. Which brings us back one more time to the trap I keep flagging, because it's the one that catches growing operators. One standardized process across a whole portfolio is the fastest route to a violation. 3 ways it gets you. What's legal at home may be unlawful 2 states over. A credit cutoff or a voucher policy that's completely fine in one market can be a straight violation in the next. The rule follows the property, not the operator. Compliance is set by where each unit physically sits, not by your headquarters' habits or your founder's instincts. And scaling multiplies the exposure. Every new jurisdiction you enter adds a rule set your one-size playbook was never written for. Consistency within a market is your friend. Uniformity across markets is your enemy. Hold both of those at once. Last piece of the current picture, and it's the fastest moving layer on the whole board: state AI laws. The headline example is Colorado. Colorado passed the nation's first comprehensive AI Act, and then repealed and replaced it before it ever took effect. It got swapped for a lighter, disclosure-based automated decision law, now set to start January 1st, 2027. And notably, housing is still a covered domain under it. 3 things to take from that. The trend is toward disclosure and explanation. Newer state laws lean toward telling consumers an automated tool was used and explaining adverse outcomes, rather than heavy pre-approval regimes. Effective dates keep moving. Treat any specific date, including that one, as provisional, because this layer changes faster than anything else we've discussed. And plan for it anyway. Build your screening now so that it can tell an applicant an automated tool was involved and why they were denied. If you can already do that, you're ahead of wherever these laws land. All right, let's pull all of it together into something you can actually use. A screen that holds up, the workflow, and the handful of habits that carry the whole thing. Here's the defensible screening workflow, start to finish. 8 steps in order. Intake, take the application. Objective criteria, the standards you set before you advertised. Qualify, check the applicant against those criteria. Screen. Now run the reports on qualified applicants only. Individualized review. Especially for criminal history and anything the algorithm flagged, a human looks at the specifics. Decision. Made by a person who can state the reason in plain English. Adverse action notice. If it's a no, the correct notice, in writing with every required element. And document and retain. The criteria, the evaluation, the reason, all kept on file. Every single thing we covered today lives somewhere on that path. Run it the same way every time, and you've turned an hour of law into a routine. You'll get this as a one-page reference to post right by the leasing desk. And if the workflow is too much to hold in your head on a busy day, hold these 5 habits instead. These survive any administration. Consistency. Same criteria, same order, every applicant. Documentation. Write down the criteria, the evaluation, and the reason. Individualized assessment. No blanket bans. Weigh the specifics. Correct adverse action. Every element, in writing, retained. And a human who can explain every denial. The plain English reason, or you don't send it. 5 habits. None of them requires a lawyer on retainer. All of them are free, and together, they're most of your defense. Let me leave you with the 4 things I most want you to carry out the door. 1. The denial is yours to defend, not the vendor's. You act on the score, so you own the outcome. 2. The law didn't simplify, it relocated. The federal pullback moved your exposure to the courts, to the states, and to the FCRA. Quieter federal agencies do not mean lower risk. 3. Your floor is now local. Source of income, fee, and fair chance rules set the real standard you're held to, market by market. 4. The algorithm is a tool, not a shield. Use it, but keep a human who can explain every no in plain English. Get those 4 right, and you're in a genuinely strong position, regardless of what happens in Washington. That's the hour. Now, I want to hear the situations you're actually dealing with, so let's open it up. Bring me your hardest one. A voucher denial you're unsure about. A vendor score you can't explain. A multi-state portfolio that's giving you a headache. A criminal history call that's a genuine judgment call. Whatever's on your desk right now. Who wants to start? Before you go, you're leaving with a toolkit, not just a talk. 3 things. The screening workflow, that one-page defensible process we just walked, ready to post by the leasing desk. The vendor question checklist, the 6 questions to put to any screening provider before you trust their score. And for those who want to go deeper, the paid deep dive, state-by-state detail, ready-to-use adverse action templates, and the actual contract language to put in front of a vendor. The first 2 are yours today. One last note, and it's an important one. Everything today was educational. It is not legal advice, and I'm not your lawyer. The rules genuinely differ by jurisdiction, and this area is moving quickly. So before you finalize your screening policies, confirm the current requirements for each property's specific location, ideally with counsel who knows that market. That said, if you take the durable spine seriously, consistency, documentation, individualized assessment, correct adverse action, and a human who can explain every denial, you are already ahead of most operators in this space. Thank you for your time today.